Thank you for holding. Parties will be on a listen-only mode until the question-and-answer session of today's conference. At that time, you can press star 1 to ask a question. This conference is being recorded. If you have any objections, you may disconnect. I'd like to introduce your speaker, Ms. Janet Wingo of the International Trade Administration.
Good morning, and welcome to this morning's webinar on enforcement issues in China. This morning, we're very lucky to have with us from Beijing an attorney who works in Beijing with 15 years' experience on the enforcement side. Edward Schmitzer-Ho will be talking about some basics for enforcement. After about 20 minutes, he will take questions and answers. You can just have the operator will explain to you how to dial in so you can ask him questions. Just a little bit about Edward. Edward has 15 years of experience in China, and he has his LLM degree in Chinese law from Columbia University. He's practicing at the firm of Schmitzer-Ho and Ferrante. Edward?
Hi, everybody. First of all, welcome to today's overview. I'm afraid I have to apologize because I'm having problems uploading the slides. So what we have today is more of the draft. And if you wait over the next few days, Janice will be uploading, hopefully, the finalized version with the various images. So if you can bear with me as we just go through the draft. And, of course, at the end, I look forward to answering any questions that you may have. So today we're really looking at IP enforcement in China, giving you more of a practical overview. The basis of the whole discussion today was really on the precept that you are a company that neither manufactures nor sells in China, that you have found counterfeits in China, and what action is possible when you have no presence in China and no registrations as well. So I've really divided the talk into two different aspects. One's organization, getting your own house into order, and then the second part is the offensive, what can be done on a practical level. So it's really the organization, getting your house in order. And that's really getting your house in order at home and abroad. I think for any SME that's facing these kind of problems, they have to work out, first of all, at home in the U.S., how are their trademarks organized, are they registered, what copyrights they have, what patents they have. And then once that's in order and everything's clarified, is to look at China. The first thing to do really when you see infringement is say, okay, we need to get registered as soon as possible. Trademarks in China take about a year to 2 years to be registered. This has been brought down from 3 years recently, and I think within the next 6 to 12 months you'll be seeing Chinese trademark registrations easily just being 1 year to get registered. Copyright in China takes about 2 to 3 months to be recorded, and patents vary, but if you're looking at a design patent, that's about 6 months. So, for example, I think when we discussed today, we were looking at SME. I've just taken sprinkles as a pure example, nothing more. But I think when you look at your own industry and your own company, you should be looking at really the different IPR. So let's say you are Sprinkles, the cupcake company. Clearly, your trademark would be Sprinkles. You would have copyright in the way that Sprinkles is written. You would also have copyright in the pack design. You might have a design patent as well on your pack design. So all of these, you've got to consider throughout the registration work in China. So when you register in China, goods and services are cut up into 45 different classes. You need to work out what your industry, what your company is dealing in, what goods and services they're dealing in, and in which class that would be in. So let's say you're doing clothes, that would be class 25, and you would ask to register in China in class 25. You generally apply for your mark in the class of interest, as well as where you may be in the next 3 years, just because it takes that certain amount of time to register. So let's say in the future, you're making clothes now, but you might say, oh, in the future I might want to make bags. That's class 18, so you'd probably register in 18 and 25. Whether you would register a Chinese trademark, it really depends if China you think is going to be an option in the future, but that could be a consideration. Remember that China may not be now, but in the future could be where your product is made. Generally, you would register in black and white because black and white covers all colors. When you're looking at a Chinese trademark. There's a number of different ways of doing it, and that will be in the final slides. We'll be going through it in the final slides. You can do a translation of your mark. For example, Apple Computers, their Chinese mark is Pingwu, which is a pure translation of their Apple mark. Otherwise, you've got two different types of transliterations. So transliteration just means taking Chinese characters that sound similar to your Western mark. A famous one is, of course, of McDonald's, that's Mai Dong Lao. And although it sounds similar, McDonald and McDonald's, the Chinese characters in themselves have no meaning. While the Swedish company IKEA has chosen a different route of transliteration, where they've taken Ijia, which basically sounds similar to IKEA, IKEA, but I means beneficial to or good for, and Jia means house. You've got to remember also that China has no intention of use principle as in the US. When you file in the US, you normally have to use your mark, or have intention to use your mark. That's not so in China. So there is a 3-year non-use cancellation action after registration if you don't use your trademark for 3 years. That's trademarks. When you look at recording copyright, you have to remember that US copyright is automatically protected in China under the Berne Convention. However, Chinese officials want to see some kind of recordal, US or Chinese recordal. So copyright can be registered in the US or in China, and you might already have the US recordal, and that will be sufficient. However, you'll probably need a notarized and legalized translation of the same, or a translation in a court-approved translation agency in China. So when you look at your brand, you really have to consider what elements of your brand are copyright, and you've got to see if you need to record it. The problem with now looking at the registration of patents is that clearly patents have a novelty requirement. So if you have already registered and used in the US your various patents, there will be the novelty issue. There is substantive examination with invention patents in China, but not with utility models and design patents. So although you might not have novelty anymore, in China you can probably get registrations for utility and models and design patents. However, they're called in China paper tigers, that although they might scare infringers, if they look carefully, they will notice that the novelty has already gone when you obtained registration, and therefore they can be invalidated for being non-novel at the time. Now it's really time for the offensive. So we've looked at, the first thing is to get your house in order and try to register your trademarks in China, try to register your copyright or record your copyright or have the US one, and patents. Either you would do a paper tiger, which is basically a patent but with no novelty, or you might have to consider other options. Another thing that you might also try to register, of course, is a domain name. So ChineseCharacters.com is registrable, and we would recommend you to do that because it does show some kind of presence in China. Now, the Chinese court and enforcement officials would welcome such a presence. So if you're taking enforcement action and you have a website in Chinese, that would greatly help, especially with trade name rights. So time for the offensive. What would we be doing? China is quite unique in having a dual track system, so both administrative enforcement and also judicial enforcement. In layman's terms, that's more like the economic police, if you want, and the courts. China gets a lot of bad press when in reality you can actually do a lot of things in China with regards to enforcement. It's one of the fastest procedures to raid. You can often raid a factory within half an hour if you have the relevant rights. There's an increasing amount of fines and damages being issued against infringers. Under the draft trademark law coming up, the statutory damages have been increased from 500,000 RMB to 1 million RMB. There are now more and more specialized IP courts with very trained judges, and there has recently been a strong push by the Chinese government to find counterfeits. This is called the Shining Sword program, and we've seen a large number of seizures both by the Administration for Industry and Commerce, that is the bureau that takes care of trademark infringement, the Administrative Bureau, as well as the court and the police. We're also seeing through the courts more cases with regard to the regulation of Chinese companies operating. And so the structure of Chinese companies is becoming clearer and clearer. What you really need to do when you find out about infringement is you need to find more about it, or who's doing it, where's it coming from, what is it exactly. You need to be clear who you're facing, what rights they have in these. If they have already started to gain rights over your mark, you should try and cancel or oppose the same. You should be using your contacts, web searchers, and investigators and law firms to try and find more information on where the investigation is coming from, how big and structured is it, and who's behind it. As much clarity is important when starting legal proceedings in China, so you can better target your strategy against the same. Remember that China is a civil law system, not a common law system, so you really need to register your rights. Very much first registration. So let's have a clearer view of the infringement. What would you do if somebody is using your trademark, if somebody is using your copyright, if somebody is using your patent, or somebody is using your company name? For trademarks, clearly the issue, as I've always mentioned before, is get registered, get registered, get registered. There is a certain amount of protection allowed under the PRC trademark law for non-registered trademarks, but that's really for well-known marks, and generally an SME trademark would arguably not be well-known. You have to remember that the well-known consideration is Chinese, so you would have to show at least a 95% well-known factor coming from China. The issue is if somebody is using your trademark, is that a case of unfair competition? And I think that's a very interesting concept, and unfortunately it's not very clear. There has been a case by a local court that has argued that although you may not be in the Chinese market, the fact that somebody else is selling your product would deem them to have considered you a competitor, and therefore possible to argue unfair competition. However, that's a local court and not a Supreme Court decision, therefore it's persuasive and not binding. You also would have to show bad faith element. How do they hear of your trademark, and how distinctive your trademark clearly is. So the more distinctive your trademark is, the more elements of bad faith element that you can show, the more you could argue that there is a possibility of unfair competition, even if you're not selling in China. But as we say, this could be very difficult, but it's a possibility and a consideration. In a prior case of Pfizer products, these Guangzhou Wellman, that was to do with the Viagra, they very much discussed the use of a trademark in China and whether that would be a problem or not. Copyright is actually your main weapon in China. U.S. copyright is protected by the Berne Convention. So basically, any use in China of your copyright could be actionable. And remember that China has this dual-track system. So there are both administrative bodies under the National Copyright Administration that would help you, as well as the Chinese courts. And with regards to any infringement, you really have to consider how much copyright has been infringed. Because out of all the rights, this is the one which will be the most actionable. So if your packaging has been infringed or your trademark, there would be copyright elements normally in that could be actionable in China. With regards to the Internet service providers have been deemed as joint tortfeasors if they have knowingly taken part in or helped others with copyright infringement. That very much follows the DMCA lines in the US, basically with the idea that ISPs are liable if they knowingly allow the publication of infringing copyright material on their servers. So websites can be pulled down, infringing links could be pulled down, for example, from Taobao or other B2B. You could take action against, as I said, infringing packaging, infringing catalogs, infringing use of photos that we often see. So I think the copyright is really where you have to start thinking the strongest. What can I do based on copyright infringement in China? Patents is a major issue. If you do not have patents in China and an infringer uses patent technology, the problem, as we mentioned, is a novelty requirement. If you came to then register your patent in China, they could be invalidated for non-novelty. patents and national rights you have to remember, like trademarks as well. Paper tigers can be invalidated in China. Arguably, however, I think in China you really have to think also of the grey areas. For example, although they're using your patent technology, have they copied your brochure? Have they copied your drawings, your technical drawings? There may be copyright in those that could be actionable. Maybe they're making claims that they relate to you or that they are linked to you or belong to you. Other unfair competition or advertising law aspects could be considered as well. Using your company name is also complex because under the Paris Convention Article 8 there is protection, but the Chinese courts would premise that your company name had been actually used in China before. The same thing with regards to unfair competition. Although you could consider a possible unfair competition action, many courts would require for there to be confusion. And the issue is if you're not using it in China, you would have to show some kind of knowledge by the Chinese consumers. Having a Chinese website, as we mentioned earlier on in the discussion, could be a consideration for this. So getting practical, the first step, once you've really found out about the infringement, is probably sending a warning letter. We often see a mistake that many people send warning letters from the US and in English. The majority of Chinese will not respect such warning letters. They really have to be in Chinese and from a law firm on the ground. We often advise clients that they should be as fast as possible so that the Chinese infringer is not seen as being legitimate. The more famous it grows, the more rights it gains, the Chinese government will see it as being more and more legitimate in the same. You really have to try and get local rights, and they have to know you're very much on the ground and that you know all about them. We would also recommend that you register your rights with the PRC customs, such as the copyrights for the PRC customs, where that would stop all the unauthorized import and export of products from and to China. Remember that there's always a possibility in many cases of increasing their heat. So if they do not heed the warning letter, you could also possibly consider enforcement in action in China out of the three intellectual property rights that we've seen: trademark, copyright, and patents. I mentioned that copyright would probably be the easiest and most effective right to enforce in China if you had no registered right in China already. So as I said, it could be admitted or judicial enforcement. Fines can be up to 3 times the turnover, and damages can be your loss due to the infringement, their gain to the infringement, or statutory damages of up to 500,000 RMB. You have to remember, a lot of infringements, a lot of SMEs come to us with regards to infringements on Taobao, Paipai, and etc., the B2B sites. All of these have pull-down programs and will pull down, for example, if there's an infringement of copyright. Let me know if you've got any questions on the above. I do apologize. As I said, there will be a finished presentation that will be put up shortly that's much more detailed than this draft overview. But if you do have any questions in the meantime, please feel free to email me at that email. And one thing a message I do want to leave with you, and a message which I think many people don't understand, is that you do have rights in China, although you have nothing registered at the moment. And it's really important for you. Many judges that you speak to complain that foreign rights owners are not taking action. I think, as you know, intellectual property is a private right. It's really for you to clarify the infringement, clarify what rights you have in China, and then act based on those rights. Thank you very much.
Thank you, Edouard. Operator, can you inform the listeners how they can call and ask a question of Edouard?
Sure. If you'd like to ask a question from the phone, press star 1. Please unmute your phone and record your name. To withdraw your question, press star 2. Once again, it's star 1 to ask a question, and you do need to record your name. Please stand by for the first question. I'm not showing any questions from the phones at this time.
Edward, while we have you online, could you tell us a little bit on how you do the recordals with Chinese customs?
The recordals are basically, so let's go back to the copyright. If you have U.S. copyright, they will recognize U.S. copyright. So you can record with the General Administration for Customs in Beijing. The process takes about 2 to 3 months. Information on the right is sent to all the ports in China, and based on that, procedures can be carried out. You would normally send a copy of your rights. You would send a list of authorized importers and exporters. If infringements are found, you would then have 3 days to notify the customs if they're genuine or not. If they're not genuine, they would be seized by customs, and they would normally investigate the case for about 6 months, after which there would be a punishment and normally a destruction of the goods or destruction of the labeling.
Would you recommend that as a point of contact you use an agent in China so that the customs can contact that agent as opposed to contacting the SME in the U.S.?
Yes, I mean normally if you're a foreigner, the Chinese would require that there be a Chinese agent who would handle customs reporting just for ease of notification.
I'm sorry for interrupting. There is a question from the phones whenever you're ready to take that.
Yeah.
Did you want to go ahead and take that now?
Yes, please.
Okay. Dan Boots, your line is open.
Thank you. Just a quick question. From our investigation, we've been advised that there's a kind of a difference in the Chinese law firms about those that might specialize in kind of trademark enforcement proceedings, such as what you've described, versus those that might just handle, for example, your trademark registration process. We have found ourselves in a situation of our trademark prosecution counsel has advised us on it's not a pure counterfeit situation, but more of a unfair competition knockoff situation of stealing a brand. In our view, is there in fact a school of thought that we need to seek out specialized enforcement counsel in lieu of our pure registration or prosecution counsel?
I think, thank you for your question, first of all. Of course, I can't discuss the actual facts of the case or who's involved because I don't know it.
Sure.
Generally in China, yes, there's a huge difference. There are trademark agents which can be set up. There used to be an exam before by the trademark office to be trademark agents. There is no longer such an exam, so anybody can set themselves up as trademark agents, and they would do all the trademark prosecution work. In China, that does not mean, of course, that they are experienced or know about trademark or intellectual property enforcement or infringement. I would definitely recommend you to go to a PRC attorney that is specialized in enforcement. I think as with any jurisdiction, enforcement is a very specialized field, not only because of the complexities of the infringement, but also the way that the Chinese enforcement structures change and the new laws that come out regularly. So definitely, I think in your case, I would definitely recommend you to look for an enforcement firm, but also a Chinese law firm. I think is very important.
Thank you.
There are no further questions from the phones at this time.
Edward, can I ask you a question? Let's say that the U.S. SME has not registered anything in China, but there's a potential safety hazard with this knockoff that's being produced in China. Are there any other avenues that you might be able to think of that would enforcement avenues regarding safety? For example, it was an electric appliance that caused fires or tended to cause fires.
Yeah, I mean, I think that's something that's very important to mention as well, is that in China, you also have to think laterally that if you have an infringement, of course you should look at the intellectual property aspects of it. I mean, something else that you will see in the comprehensive slides, and I really do recommend you to have a look back in the next few days for the comprehensive slides, is that there is a section also with regards to contractual. You know, are these infringements appearing because you met somebody at a fair who signed a confidentiality agreement and suddenly they're producing in China? You have to think laterally, and I think, as you mentioned that, Janice, that's really important also with the health issues. If there are infringements being made with health issues, China also has a set of specific laws that will address these. There is a body in China called the Quality Technical Supervision Bureau, and that's similar to the Administration for Industry and Commerce. As I mentioned, the Administration for Industry and Commerce, or AIC, deal with trademark matters. The second body, the Quality Technical and Supervision Bureau, QTSB, will deal with consumer issues, labeling, and quality and health issues. And they will, more and more so, they will take really quick action against such infringements. Although it may not resolve the matter in the long run because they could, you know, possibly increase the quality and make it better, in the short run you can get a very strong reaction to such infringements, including seizures, fines. So, yeah,
so if the good says made in USA when it's being made in China, that's potentially something you can take to the QTSB?
Exactly. That, I mean, things like labeling, consumer protection would all go to the QTSB, and that's actionable through that. And that will be in my finished slide as well.
Which will be posted in 3 to 4 days on the stopfakes.gov website.
There are no further questions from the phone.
Well, if there are no further questions, Edouard, we thank you for your time this morning. I know it's quite late in Beijing. And anyone who is listening at home, Edouard said he'd be happy to take questions via email. His email address is up there. So again, thank you again for listening.
Thanks very much.
That concludes today's conference. You may disconnect at this time.
Thank you. Bye.